Jacob Rees-Mogg.
Thank you, Mr Deputy Speaker. It is an enormous pleasure to follow my honourable friend, the member for Penrith and the Border. I think that is one of the most instructive and thoughtful speeches that it's been my pleasure to listen to in this chamber. That is, I'm afraid to say, a preamble to saying that there's a good deal of it with which I disagree, but I mean very genuinely that it was a fantastic exposition of a defence of human rights to the extent that we have them. I think there are difficulties with it as a view. As we discussed in various interventions, the question of absolutes is very difficult in a political context which law ends up being. In terms of moral absolutes, I have no difficulty wearing a Catholic hat to accept them, that I believe there are very clear moral absolutes that are established by the Church. But the state is something very different from that and has pressures on it that mean that the moral absolutes have to be dealt with in the context of the time. The obvious example is the definition of a just war. And we know that that is a definition brought forward by Thomas Aquinas, that it sets down the three conditions for a just war, to overcome how states can deal with a problem that threatens their own existence against a Christian teaching, which is that you should turn the other cheek. So that we find that a moral religious absolute is simply impractical in terms of the secular behaviour that states, governments, nations require. And then when we look at individual bills of rights or lists of human rights, they are not moral absolutes. They are a question of dealing with political problems that exist at the time at which they are drawn up. And my honourable friend gave the wonderful example, of which I was unaware, of the United Nations Human Rights Convention that maintains the right for paid holiday. It is very hard to believe that the right to paid holiday is an absolute moral right. It is something that comes about because of political pressures at the time, because of negotiations between the drafters, and those sorts of things that lead to the political decision-making process. To look at the bill that we have in front of us, you see that some of the rights that are being insisted upon in the British Bill of Rights relate to immediate and specific problems that we face. There is a part on voters' rights for prisoners, there is a part on the right to self-defence if your property is attacked. These are at the forefront of political debate at the moment. And so, good document though it is very hard to argue that the British Bill of Rights we have in front of us is some eternal moral document that will stand for 1,000 years. The American Bill of Rights, again, deals with specific problems that they thought they had at the time at which they were drawing up the Constitution. Very, very interestingly, in the Constitution itself, rather than in the first 10 amendments, is the part on how acts of attainder are limited. They may not relate to blood, and they may not affect the next generation. An act of attainder was something that was an immediate political issue when the American Constitution was being drawn up, which is of no relevance today. So I would dispute the point that bills of rights, that human rights legislation is dealing with moral absolutes. I would argue that instead they are dealing with political problems, and I mentioned the example, the wonderful example from our own Bill of Rights, of the need to maintain a right to bear arms, to maintain a Protestant militia. Again, it comes in immediately after you have had a Catholic king and a fear that he will use arms to enforce Catholicism on the country, and you need a Protestant militia to defend you against that. Wonderful and antique though that is, it is not an eternal, everlasting moral principle. Indeed, I don't think eternal, everlasting moral principles very often go very well with the day-to-day practice of government and legislation. And therefore, to go back to the 4 points that my honourable friend made, the first point is the overwhelmingly important one. It is the one of legitimacy of that political power that is making these decisions that may then be altered by a subsequent political power. The next 2 points, the issue of triviality and inconvenience, I think were arguments set up to be knocked down. They're clearly wrong-headed, that it is absurd to say that some aspect of law is so unimportant that somebody shouldn't have the right to bring a case of it, and equally that if something is inconvenient, governments can just override it, would lead us with no rule of law at all. So it's really the first point and the last point that are essential. It's against this fourth view, as I would see it, of is there this essential morality that we can bring into our legislative system against whether it is in fact a matter of political legitimacy, and I would go for the political legitimacy. And it's very interesting how well our constitutional settlement has served us. My honourable friend for Penrith and the Border and my honourable friend for Dover and Deal have both referred to the Magna Carta and have said that we have had 800 years of these rights. Well, actually, the Magna Carta is a confirmation of rights that it was thought that we already had. Habeas corpus, when that is brought in 1685, is a confirmation of a right that it is thought that we already had. The Bill of Rights itself is about confirming rights and stopping abuses of those rights that have been done previously. And the approach to this is using the development of powers within this country, the barons in 1215, Parliament in the 1680s, to assert these rights against an executive that was abusing them. And we come to the position of Parliament in this. A great deal is made of parliamentary sovereignty, and I am indeed a great defender of parliamentary sovereignty. But it is not an end in itself. Great, powerful and noble though these two houses are, we are here as the servants of the British people with whom authority and legitimacy lies. And that is the great safeguard, I have always thought, of our rights and of our liberties. And that is that at a maximum 5-year period, the British electorate have the final say as to whether or not we are to continue in office or whether somebody else is to be given a chance instead. And that seems to me to be at the core of the legitimacy argument. That the rights are the rights of the human people, the individuals, who make up the United Kingdom. And they may aspire to international rights, and that may be a wonderful ideal, but it is not one of practical implementation or of politics. And they have the right to suspend those rights from time to time when they see that there is a dire emergency. I'm a great believer, Mr. Deputy Speaker, in habeas corpus as one of the most important rights that we all have that defends us from arbitrary government. But do I think that Pitt the Younger was right to suspend it during the Napoleonic Wars? And do I think it was right to lock up fascists during the Second World War? Yes, I do. It was correct to suspend a fundamental right when the nation was under fundamental attack. And there could be no court outside this country that could conceivably judge whether under... Of course I'll give way.
Mr. Deputy Speaker, just to confirm, the Honourable Member for North East Somerset seems to be in a measure of agreement. This argument that there is a right, possess a right, habeas corpus is possessed, but under certain extreme threshold circumstances that right could be suspended, appears to be in agreement with the notion that there is such a thing as a right, that there is a form of inviolability, but in certain situations it might be set aside.
My point of difference with my honourable friend is on whether this is an absolute right that you can enshrine or whether it is fundamentally arbitrary, because once you have to negotiate the threshold, the absolute quality of that right has disappeared. So it is not an absolute moral right. It is something that is part of our ancient liberties that we are justly proud of, and I think it's very important to maintain. But it is a liberty that can, under certain circumstances, be suspended, and then it's a question of whose judgment is legitimate in that suspension. And in my view, the only possible legitimate authority for suspending that liberty has to be that body that represents the democracy that is at issue. And it cannot be a foreign body or an overseas democracy that can do that. It has to be belonging to the people who are affected by it. And so, yes, I do see in a religious context that there are absolute morals, and they may or may not be judged by a higher court at a much later stage in our lives. but they are not ones that are easily convertible to a temporal, secular society which has to deal with the immediate issues of the day. So the ancient liberties that we've got, I think, are a crucial defence of us against an arbitrary government. And I think the constitutional settlement that we have, in spite of the ease with which the Constitution can be changed, has been a great protection of those rights, and actually a much greater protection of those rights than all those countries with careful constitutions. If you think, for example, of Guantanamo Bay, the US government has managed to say that that is constitutional. And if you can find in your detailed constitution a legitimate way of doing something that is in fact outrageous, you are able to do it because you're able to say we're following the letter of the law. Whereas in our nation, we are always following that spirit of our unwritten constitution that politicians have to live within and abide, because they can't go back to the electorate and say, well, we're following the letter of the law in doing this outrageous thing in all other circumstances, and therefore we can get away with it. I think the whole row we've had over TPIMs and control orders relates to that. Because they obey the letter of the law, we have introduced something of an incredibly arbitrary nature, an unjust nature, because it meets the definition of the European Convention on Human Rights, as interpreted by our own judges, against something that was actually much fairer, which was saying, as an act of the British Parliament, that if you were a foreigner living in this country, who we did not want living in this country, you could either leave or you could stay in prison. And that seemed to me a perfectly reasonable thing for a sovereign parliament to say. The court said that that was not compatible, so you come up with something that is compatible but fundamentally unjust. And that is the problem you get into when you try and impose absolute rights on a governmental system that needs to work with a degree of flexibility, and that we all accept that that flexibility is necessary. And it is then just a question of the examples that you need to determine it. Of course, I'm going to.
Thank you, Mr. Speaker. The challenge in this analysis, which is very moving and convincing, is that it puts a very, very high degree of trust in the seriousness, the historical knowledge, the culture of the Parliament itself. If Parliament itself ceases to take on its responsibilities with that level of seriousness, if it starts to make trivial changes to the Constitution for reasons of political expediency, how could the British public be protected against its government?
I'm very grateful to my honourable friend. I think it's a matter not of trusting us, the politicians, but of trusting them, the British people who send us here in the first place. Because if we start playing fast and loose with the British Constitution, there will be an election and we can be thrown out. If we use our powers arbitrarily, then we can be thrown out. And actually, there are pieces of superior law under our Constitution, and one of those is the 1911 Parliament Act, which specifically protects the life of a Parliament against an extension purely by the House of Commons. And so there is an inbuilt reservation to ensure that we have to go back to the electorate to get their permission to carry on with what we are doing. And that arbitrary governments do find that the British people want to get rid of them. Governments that extend beyond the powers it's thought legitimate for governments to have. Indeed, it was a major issue at the last election. It was part of the area where the Conservatives and the Liberal Democrats were most together, because we were advocating the ancient liberties of the subject against the Labour Party, who was constantly infringing those and putting more and more powers into the hands of the state. And the British electorate, in their wisdom, decided to put in to office two parties who were committed, at least when they were in opposition, to preserving the freedoms of the British subject. And so I think we've seen it tried and tested, and it actually works. And I'd make a further point, which is that once you start saying that this House of Commons, these two Houses of Parliament, are not capable of making these decisions, and that you must hand them over to unelected judges overseas, then you undermine the confidence of this House to deal with matters properly. You give an incentive to this House not to take its responsibilities as seriously. Why? Because if we get it wrong, there is somebody else who can clear up the mess. So if you leave the responsibility here, I think that makes us take more seriously the duties that we have as parliamentarians and the obligation we have to protect our constitutional settlement. And to come back to this key issue of legitimacy, and I choose the phrase legitimacy deliberately rather than sovereignty, because it is about doing what is acceptable to the people to whom it is being done. And for that, you require a body of people that have a sufficient unity of purpose to accept that what is being done to them has legitimacy, even when they themselves are in a minority in opposing it. And when we in Britain are in a minority opposing a judgment of the European Court of Human Rights, we do not feel that that is a legitimate minority for us to be in, and that majority that has overruled us has a proper authority to do it. And therefore, when our courts come out with a judgment that is not in relation to human rights, we may rail against it, we may be cross about it, but we accept it as legitimate. When Parliament passes acts that we as individuals don't like, that minorities oppose, we accept that Parliament has the legitimacy to do it because we attach ourselves to the whole of the United Kingdom to accept the legitimacy.
The honourable member very much for giving way. This is a very powerful and moving speech. A lot of it is immensely appealing and convincing. There is a problem, though, which is that we set up this court, and we seem to be quite happy with it, so long as it was going around telling other countries how to behave, with all these problems of illegitimacy, all these problems of undermining the sovereignty of other people's parliaments, didn't worry us at all, until this court that we created turned around and started telling us off.
I don't disagree with my honourable friend at all. I think we do take the view, the rather foolish view, when we set up these courts, that they will never affect us. And so you take the International Criminal Court. Nobody ever thinks that any senior British politician might be hauled in front of the International Criminal Court. Now, if that ever happens, we might suddenly decide that we weren't so keen on the International Criminal Court, and I actually admire the judgment of the Americans who have not joined the International Criminal Court because they recognise that if it is justice for one, it is justice for all. And I think as a strong, independent, sovereign nation, with a history of behaving well, going back way before Magna Carta, we ought to be able to settle our rules for ourselves and be very cautious of setting up these courts that are essentially victors' justice. Because what we were really doing with the European Court of Human Rights was saying, we have defeated all these nations of Europe. They have had terrible dictatorships before. They're not like good old Blighty, and let us therefore show them how to behave like gentlemen and give them this court and this convention. And then when they started saying to us, well, now you too must behave like gentlemen, and of course ladies in this modern age, we didn't like it, because we thought it affected and undermined our sovereignty. And to slightly split my infinities, no, to sit on the fence to a degree, I think after the war, with very immature democracies, it might have been a help to them for a limited period to have some guidance to help them reform and rebuild themselves. But I no more think that Germany needs to be guided by a European Court on Human Rights than the United Kingdom does. I no more think Italy needs to be guided by a European Court of Human Rights than England does. I do not want to impose a rule of foreign... Of course, I give way.
Challenge, of course, Honourable Member for North East Somerset, is that it isn't primarily Germany or Italy that people are concerned with. What people would be concerned with is that by leaving the European Court and dismantling this infrastructure that we've created, its real purpose and influence at the moment, which seems to be directed towards countries from Russia and throughout Eastern Europe, would be undermined. It's the countries that are still perhaps in the situation in which the Honourable Member described, for whom the court exists and for whose sake we would be tempted simply on a basis of foreign relations contribution to these countries to continue to participate in these organisations.
Mr. Deputy Speaker, that was the former Mandarin speaking, I'm afraid to say, that it's the Foreign Office view of the world that we have to do all these things that undermine our own constitution because it makes it nicer for us when we're dealing with our colleagues overseas, and it may influence them a little and all of that. I would never, Mr. Deputy Speaker, give up one whit of our constitution for a minor diplomatic advantage. The proportion of benefit to us for guiding our own constitution, for safeguarding the democracy of the British people, against thinking we can influence President Putin by half a...
Powerful point from the Honourable Member for North East Somerset, of course undermined by the Honourable Member's statement that it made sense after the Second World War exactly for us to give a limited amount of sovereignty to this organisation in order to create exactly the peace and stability in Europe which was so central to the welfare and security of the British nation.
I'm glad to say, Mr. Deputy Speaker, I didn't undermine my own argument because my honourable friend may not be aware that until 1969 Henry VIII's Act in Restraint of Appeals was still on the statute book, and therefore until 1969 it was treason to take an appeal out of this country to a foreign court. So from 1950 to 1969 it was impossible, illegal, treason for the European Court of Human Rights to rule against the United Kingdom. So we had set something up that was very beneficial for people who had emerged out of war without there being a risk of anybody appealing to it, except from Northern Ireland where the repeal was a bit earlier, but that's slightly beside the point. We were safeguarded by our wisdom in not repealing rather more ancient laws with which I have a certain sympathy, as it happens, because I think when we had that confidence to be a nation standing on our own 2 feet, at that point we said we will not have any appeals going outside this country. Case in point then was the papacy. When we felt a weaker nation, a nation in decline, a nation where the business of politics is managing decline, where we cannot look after ourselves, then we have to have a foreign court that is the final safeguard and fallback of what we are trying to achieve in this country. I simply don't believe that that is the right way to do it, or a legitimate way to do it. I do not see that our membership of the European Convention on Human Rights has sufficient influence on other countries. I would of course give way again if...
Say we were to go with the Honourable Member for North East Somerset's proposal to leave the European Convention, leave the European Council, what would be the way in which the Honourable Member would explain to the other European countries that having created this court, drafted the European Convention on Human Rights, trumpeted it, helped to impose it on other governments, we have suddenly decided that we no longer wish to be a party to it?
Well, we've created an awful lot of things that we don't necessarily still run. We, after all, created Belgium, and we don't claim to run Belgium having created it. I think we have a very good argument to make that our legal system and tradition is fundamentally different from the continental system, and that the common law has built up protections over generations which are different from those in the Human Rights Declaration. And indeed it was probably a mistake for us ever to sign up to that declaration. I'll give way.
The Honourable Member for North East Somerset, in other words, would be saying to the European people, we made a terrible mistake. 60 years ago we created this thing, we spent a long time as Conservative and Labour governments saying it was a great force for civilization and progress. We sent some of our most distinguished barristers and judges to this court. We celebrated its judgments. We used it to put pressure on Eastern Europe and Russia. But we've decided this was all a terrible mistake, and actually we will leave, and we would encourage other countries to leave, and the whole European court system can collapse. And the consequences for what that means of our commitment to human rights and our attitudes towards Eastern, Central Europe and Russia can take its own course. Would that be roughly the version of the Honourable Member?
My honourable friend says we celebrate judgments. It's very hard to think of a large number of judgments of the European Court of Human Rights that we've been celebrating. I don't remember any jubilee parties for judgments of the European Court of Human Rights. And of course I'll give way, but before I give way, the honourable gentleman will be aware that there are many, many judgments that we dispute and dislike.
Honourable Member for North East Somerset, would agree that we celebrated very, very strongly the European Court's rulings on exactly the issue of habeas corpus, of which he's so rightly proud. We took enormous credit for the fact that the European Court introduced elements of habeas corpus, a notion of no detention without trial, took on cases of torture, and transformed the political economy and the human rights of southern Europe. And we used this as something of which we were immensely proud, and as part of our foreign policy and a part of a contribution to our own security. Are we now moving away from all of that, or are we saying times have changed?
My concern is how the European Court of Human Rights operates in this country. Just because we leave, it doesn't mean other countries can't remain part of it. And the key reason that it is so difficult for us is because of this difference between the common law and Napoleonic law, and this whole fundamental basis of rights, that in England and Wales, you have, under the common law, the right to do anything that is not specifically prescribed by law. That is a very different system from the continental system, where you have the right to do what you are allowed to do. And therefore you need a detailed list of rights for a European system to set out what you can do, whereas here you only lose rights when Parliament, through its democratic process, has decided that they need to be taken away in the interests of the state. And that might be your right to liberty for committing a crime. It might be your right to vote because you've committed a crime and lost your liberty. But those are decisions made under the common law by Parliament. It is not a question of having a defined list of rights of what you can do and then assuming that anything outside that you can't do. And I think our system of rights, in common with the Americans, actually produces a much freer and better system of protecting ancient liberties, which I hold very dear, than having a system of specific rights which, if you come into contact with them, may provide you with some judgment, rather than being free to do whatever is allowed. And yes, of course, there are elements of the Convention that I am all in favour of. I don't want us to pull out of it and then start torturing people. But it's worth bearing in mind why the common law did not have torture, and how our system developed without torture and the continental system developed with torture. And it all goes back to 1215, when, interestingly, we get Magna Carta, and interestingly, they have the Fourth Lateran Council. And the Fourth Lateran Council states that trial by ordeal cannot be supervised by the Church. And because the Church can't supervise it, it cannot be the will of God. And therefore you can only find somebody guilty in a continental system if you extract a confession. Hence, for very good reasons, for moral reasons, the Fourth Lateran Council gets rid of trial by ordeal, and the law of unintended consequences is it leads to torture being routine in the continental judicial system. And here, at the same point, by chance, by good fortune, because the barons have come up against the king, we get the rights of liberty preserved, and we get the continuation of the development of the jury system of a means of getting to truth, again dropping the right by trial to ordeal, because, of course, at that point, pre-Reformation time, we were still tied up to the doctrines of Rome. So you see how our systems have diverged very sharply. And when you're coming from a system that has had these issues with torture being an instrumental part of it, then yes, of course you need to define the rights more carefully, because that's not what they've had before. They have needed them to be imposed. Just anyway.
Make this my last intervention. The Honourable Member has spoken very well about a notion that deeply somehow rooted in Magna Carta is a British immunity to any of these temptations. The problem, however, is that we're facing very different kinds of challenges today. And it's very difficult to believe that the kinds of mechanisms which the Honourable Member is talking about, which are primarily mechanisms to do with the expression of backbenchers' opinions in the House of Commons and elections, a 5-yearly election, can have a fundamental effect on an issue such as, for example, predator drones. How would, for example, the Honourable Member for North East Somerset deal with the question of predator drone assassinations? How would the Honourable Member for North East Somerset explain how continued British tacit participation and knowledge of assassination by predator drones has continued for 3 years without this Parliament touching on it at all, and as far as in my very junior position as a new Member of Parliament can see, without any intention of really touching on it in the next few years? And in the absence of any code of rights, in the absence of anything to which one can appeal to protect people, how on earth is one going to have protection for citizens?
Well, Mr. Deputy Speaker, I think that is essentially a matter of politics and the doctrine of the just war. If we are involving ourselves in predator-drone strikes, do we meet the three criteria of a just war? Is there sufficient cause? Are we a legitimate authority? And is there a reasonable prospect of success? And it is for the government to make that case, and if the government cannot make that case, then ultimately Parliament will have to decide. But I would certainly not put the safety of the nation in the hands of a bunch of judges overseas. That is the worst possible example for the honourable gentleman, my honourable friend, to use, even though I'm actually rather sympathetic to his basic point that using drones is not something the British should be involved with. But the decision for that, the decision on our own national security, must surely rest with the executive held to account by the legislature. Because that ultimately is why we are here, Mr. Deputy Speaker. It's why we're here since Parliament was first assembled. We are here to bring redress of grievance against the Crown and against the ministers of the Crown. And it is our job when representing our constituents and in the legislation that we vote on and in the questions we put down to redress grievance where the rights, the liberties, the freedoms of our citizens have been undermined. We do not need an overseas court to do that, and indeed to the extent they do it, it reduces our ability to do it for our constituents because they appear to be the legitimate authority for redress of grievance rather than this House. So, Mr. Deputy Speaker, I think this bill is a step in the right direction. There's not every dot and comma of it that I will agree with. If I'm asked to serve on the committee, it will be a privilege and honour. I would like to see it slightly simplified, and I would like to see it remove the European Convention altogether. Indeed, I'm not entirely sure that I wouldn't like to see the Act and Restraint of Appeals returned to the statute book to apply a slightly higher penalty for appealing outside this kingdom to foreign courts, because it is, in essence, the legitimacy of our democracy, the legitimacy of Parliament, the legitimacy of each member here representing our constituents that defends the liberties of the British people. Because if we fail, if we don't defend them, if we pass them off to somebody else, then the British electorate can get rid of us, each and every one of us, and put in our place people who will stand up for their liberties.